Last week I was in a deposition of a client that we were representing, and the issue came up as to what was the employer's obligation under the law under the FMLA, the Family Medical Leave Act, in California's version called the California Family Rights Act. In this situation, the employee unfortunately had a medical condition that prevented the employee from being at work for 10 weeks. They had a medical operation and underlying medical treatment that prevented them from doing any work for a 10-week period. After that 10-week period, they had follow-up visits. The follow-up visits happened every Friday, but as a result of the treatment, that employee couldn't work for a day or two after the follow-up treatment. But the employee typically worked Monday through Friday. And so they were seeking leave under FMLA every Friday so they could go seek follow-up treatment for a 10-week period. And so Family Medical Leave Act and the California Family Rights Act are pretty similar. And it provides for 12 weeks of leave per year, either on a continuous basis for 10 weeks or on an intermittent basis or a combination. So in this circumstance, they had family medical leave or CFRA leave for a 10-week period to be followed up for intermittent. And so every Friday they would take off for leave. Now, the employer actually gave this employee the 10 weeks off. But when she said, I needed time off every Friday to go seek treatment, the employer said no and they terminated her. We spent a lot of time just establishing that at the time they made that decision, she still actually had 2 weeks of FMLA leave available, basically 10 days. And that under FMLA and CFRA, you can take that FMLA leave on an intermittent basis every Friday to go seek treatment, or 3 times a week if you needed that treatment. Under the FMLA and the CFRA, you're entitled to that leave. You're also entitled to a situation not to be retaliated against for taking that leave or interfering with your ability to take that leave. Even when all your leave is taken under the CFRA and the FMLA of 12 weeks, please understand you still might have protection under the California's Fair Employment and Housing Act as a form of reasonable accommodation. And so even if all your treatment isn't done within that 12 weeks, then you just still need a little bit more time to go get better. That unless the employer can show that it'd be an undue burden to keep that position available to you or not terminate you, that you would have leave available to you as a form of reasonable accommodation beyond the 12 weeks. Out of all the areas of law that we do, calculating how much leave an employee is entitled to as to whether or not it's an undue burden to keep the position available is one of the hardest areas of the law that we practice. If you have questions as to what your entitlement is at your current employer, or if you're no longer working for a company because you took FMLA leave, or the employer told you that you didn't have any more leave and they had to terminate you, whatever the case might be as it relates to your disability, if you have questions, feel free to give us a call. I'm happy to answer any questions that you may have.